New filings in the Steve Bannon case. We can see several new docket entries from PACER, which is the federal court docket system. Take a look here on June 17th, 83, 84, and 85. We'll get to each of those today, do them relatively quickly. But before we dive in, remember last time on the 15th, we talked about the minute entry. Steve Bannon had court this week. He was there with his lawyer. They were there making arguments on a motion to dismiss, trying to get the whole case thrown out. Several different arguments talking about the committee being illegally constituted, talking about certain things like executive privilege. And we know the trial is coming up in mid-July, right around the corner, and they are gearing up for this thing. And it's not a real complicated trial because it's really only two charges. One is contempt of Congress for for not showing up and providing testimony. The other is for not showing up and providing documents, all coming from, in my opinion, the fake illegally constituted January 6th Select Committee. I say that because they're supposed to have 13 members, 5 of whom were appointed, in my reading of it, with consultation of the minority party, Republicans. They're not. There's only 9 members, 2 of whom are Republicans, and we know that they're not even really Republicans. Liz Cheney and Adam Kinzinger, not even going to be there in Congress entirely, whether as Republicans or Democrats at all, come next term. So they had all of those arguments earlier in the week. And then we know at that time, the judge basically said, no, trial is staying on. And so we're not going to be, moving this forward, not going to be a continuance. The judge said, I've got a couple of other issues that I want to resolve on some of these other filings, but I'm going to hold off on them until we get the jury instructions completed. And so those are due by 6/30/2022. We know as well that Mr. Bannon, of course, is out on his own recognizance. He made several statements with his lawyer, and we covered that on a live stream previously in the week. So, of course, make sure that you subscribe if you want to follow along with the Steve Bannon case, because his trial is coming up. And when trial comes up, there's stuff that needs to get done to make sure the tile is nice and tidy so that things are sort of clean around the margins and that things are moving forward properly, that the trial doesn't, get off focus or have any problems. And what lawyers do is they file these documents. You see, it's called a motion in limine. And so these are preliminary motions to sort of make sure that things are on track, because the last thing you want in a trial is, despite what Hollywood shows you, is you don't want a witness at the stand and somebody pulls out the magic bullet and they go, aha, what's this? And you say, oh, well, I didn't know that you actually had that. And then, well, it needs to be disclosed, and you argue about those things. Can we use that in trial? Yes or no? If the answer is no, then you can't pull it out. And so, you have to disclose evidence before you can use it, so the other side knows you have it. And so there's a lot of rules. That's why we spend hundreds of thousands of dollars to learn them. But it says motion in limine, and this is a preliminary motion. What this is saying is that Steve Bannon, you can see it's filed by him. They want to do something, limit something on presenting the indictment to the jury, right? And the indictment is the original charging document where we see what Bannon allegedly did. So we've already covered that at length. And it's, of course, on our mind map where all of this gets connected together at j6mindmap.com, free website. And it sort of lays all this out as a buffet of nefariousness, if you want to go check that out. But the other motion that was filed by Steve Bannon and his team is this one. It's called a motion in limine precluding evidence or argument regarding the attack on the Capitol. So it sounds like now what they're trying to do is stop the government from talking about the Capitol attack, because he's not charged with the Capitol attack. He's only charged with not showing up to Congress, right? He got a subpoena. Subpoena is only for documents and testimony. He's not charged with insurrection. He's not charged with trespass. He wasn't even there. He's not charged with conspiracy or seditious conspiracy, like Enrique Tarrio, former FBI informant, is, or like Stuart Rhodes, best friends with Ray Epps, like he is. So it's difficult to piece all this together. So why would they be allowed to talk about the Capitol riot when he's not charged with that? Remember, we had a similar problem when we were talking about Michael Sussman. Michael Sussman was only charged with 1 count of lying to the FBI. And so his defense attorneys argued convincingly, I think it's a good argument, that they shouldn't be allowed, speaking about the Durham prosecutors, to talk about the Hillary Clinton conspiracy, to talk about the idea that, she was involved in creating the white papers or these fake dossiers, or that Rodney Jaffe was connected with the DNC. All right, the jurors didn't get to hear a lot of that because they said it was too prejudicial. It was too far removed. Same type of argument could be here. Steve Bannon is not charged with insurrection. So why would they talk about insurrection or anything that went on at the Capitol building when he's not charged with a crime? He's charged with a process crime, not an actual January 6th crime. So he's going to say you shouldn't be allowed to talk about that. And then we'll take a quick look at the government's motion. This is filed by Amanda Vaughn, who is a U.S. government prosecutor. She filed her omnibus motion in limine, which means it's just a big fat motion with all of them in there, right? They're not separating them out, sort of like the Bannon defense team. Matthew Corcoran is here. They're slopping them all in together. All right, so here's what we got. Now, these are quick, and we can run through them relatively quickly. First one we have is a motion in limine precluding. Actually, we're going to go over here to look at these. This one is a motion in limine on presenting the indictment to the jury. Okay, so we want to talk about crafting some rules about the document going in front of the jurors. It says defendant Stephen Bannon, by his counsel, moves in limine for a pretrial ruling that the entirety of the indictment in the case will not be read to the jury, nor will the jury be given the indictment during its deliberations. And that's the big charging document. I mean, how are they going to know what he was charged with if they can't read the indictment, is what the prosecutors are going to say. But he's going to say a lot of that stuff in the indictment is irrelevant to the criminal charges at hand. He says on November 12th, Bannon was charged in this indictment after allegedly saying he received a subpoena issued by the committee that constituted contempt of Congress. It is a well-settled in our law, writes this attorney, that the indictment is not evidence and therefore it should be thrown out or not part of the evidence. He says the indictment in this case is, quote, a speaking indictment. Its first 7 pages make a variety of allegations, each of which would need to be proved by competent evidence introduced at trial in order for it to be considered by the jury. Bannon therefore requests the entirety of the indictment not be read to the jury during the trial or given to the jury during its deliberations. We have no objection, however, to the language of count 1 and count 2 being read and presented to the jury. Wherefore, Mr. Bannon, all agree with this, signed off on by M. Evan Corcoran and David Scone, submitted to the judge here on June 17th, 3 pages. And so pretty simple stuff, right? Saying a lot of the indictment is setting the framework. It's the background. It's the history. And we've covered it. It's on the mind map. It's got a lot of the background, the election happened, Donald Trump was doing this, blah, blah, blah. Well, Bannon is not indicted or charged with any crimes related to that. He got a subpoena, he got a letter from Congress, and he didn't show up to their birthday party. He got an invitation. Will you please come and hang out with us? And he said, no, weirdos, no. And they said, well, that's a big problem. We're offended now. And you're a terrorist now because you didn't come to our birthday party. All right, so he's saying now you can't talk about the stuff that's not relevant, right? You can only complain about the not coming to the birthday party. You can't complain about whatever happened, at school the day before then. It's a whole separate issue, and you can't correlate the two or mash them together. All right, so that's one motion in limine. The other one you can see, very similar structure. It's another 4 pages, a little bit longer. It's another motion in limine saying that they've got to preclude evidence or any argument even, right? So they can't talk fact or make arguments regarding the attack on the Capitol. Similarly, Steve Bannon and his lawyers file this document under Rules of Evidence 401, 403 for a pretrial ruling that stops and precludes the government from presenting evidence or argument at trial about the January 6th attack. In support of this motion, we state as follows. They lay out some case law saying that we've got authority to determine how these issues work before the trial starts. And they tell us once again, similarly to what we saw, that previously on November 12th, Bannon was charged 2 counts in the indictment saying that there was a January 6th Capitol attack that took place. They say all of this has no bearing on whether Bannon willfully made default in response to the September 23rd subpoena. Meaning he didn't show up, right? He defaulted on the requirement to show up. Thus, any evidence or argument regarding those events should be precluded. They're not relevant. Even if one were to assume that any evidence about J6 was relevant, it is not. The evidence in the argument must nonetheless be excluded under Rule 403. Very common rule. They're saying it's too prejudicial. He says it here. Its probative value would be far outweighed by its prejudicial effect. You put it on a balancing scale. You say, does this piece of information do more harm than good? That's what the 403 balancing test is. If it's more probative than it is harmful, if it gives us more good things, more useful data than it does harm, well, we'll let it in. But if not, well, we're going to keep it out. It's sort of a broad catch-all rule that comes up all the time. It says this is especially true given that the trial will take place in Washington, D.C., where the Capitol is located, because images and commentary about the attack and the subsequent actions of this select committee, they've saturated the local media. So Bannon, by his counsel, we say, look, Judge, you've got to grant a pretrial order and stop the government from presenting any evidence at all, including but not limited to testimony, argument, documents, photos, videos, audio recordings, or any details that depict the J6 attack on the Capitol. Right? What they don't want to have happen is prosecutors to come in and play their stupid videos that they've been playing in front of the J6 committee. You know, one right after the other. Which, of course, they couldn't, because this is a regular court of law. That one is not. That's a fake kangaroo court that, as I've said many times, in my opinion, is illegally constituted. But judges apparently are continuing to entertain it because Congress is a co-equal branch. And they say, well, I guess you're Congress and you run the Justice Department, so do whatever you want. So, all right, so that's Bannon's motions, 2 motions in limine. This is the government's omnibus, and you can see this is a little bit longer, right? It's an omnibus. It's got a bunch of stuff in there. And we'll run through it quickly, just taking a look at the highlights. It says, all right, this is the United States' motion. Here he says, the question for the jury in this trial is pretty straightforward. Whether the defendant deliberately refused to comply with a subpoena issued to him by the J6 committee. But in his filings at oral argument and during press conferences in front of the courthouse, the defendant has repeatedly sought to inject into this case improper evidence and argument, make incendiary and baseless attacks, and create a spectacle. To maintain proper order and keep the jury focused on its fact-finding, the court should exclude any such improper evidence and argument at trial. And Bannon did give a court proceeding. I don't even think he cares about this case. People were asking him questions about it, and he said, did you see the elections yesterday? They were crazy. We're killing them. We're winning all over the place. It's going to be a bloodbath come November. They're like, yes, sir, you've been indicted for 2 crimes. He's like, I know, but MAGA's returning, baby. Don't worry about it. We're going to rule for 100 years. Reporters are like, oh, okay, well, all right. And we talked about this on the show yesterday. It was like, interesting strategy. I never thought about that as a defense. Just waiting until Congress changes power and changes the rules. I like it. So the prosecutor is saying, you know, this has become political. And it's like, well, of course it is. This whole thing is political. You guys started it, by the way. And so the prosecutor, Amanda Vaughn, is writing, the court should preclude the defendant from making arguments, presenting evidence, questioning witnesses about politics, baseless government misconduct, and other incendiary or irrelevant topics. At a press conference in front of the courthouse, the defendant made the claim that this thing was a scam from the beginning. He says, I'm telling you right now, this is going to be the misdemeanor from hell, and that he was going on offense. They cite a YouTube channel. In his filings, the defendant basically accused the government of misconduct and intimidation, also asserted that this is politically motivated prosecution. Of course it is. It emanates from the January 6th Select Committee, which is a democratic institution. It's not even legally constituted. Of course it is politically motivated. As recently as this Wednesday, writes this prosecutor, at another courthouse press conference following the motions hearing before the court, defendant expressed interest in turning this trial into a political spectacle, referring to members of Congress using derogatory nicknames, saying, I look forward to having Nancy Pelosi, little Jamie Raskin, and Shifty Shift in here at trial answering questions under the, he says, the tough thing about my lawyers. The trial judge has the responsibility to maintain decorum, they citing the U.S. Supreme Court. You better keep this thing in order, Judge, because Bannon's turning this into a circus. And so they say the court has broad discretion to prevent a circus atmosphere at trial and must exclude evidence in order to do so. And the court must guard against arguments that seek to encourage jury nullification. Yeah, right. Like that's going to happen in D.C. Are you kidding me? Jury nullification in D.C. against Steve Bannon? They're going to walk in and look at him and they're going to say, electric chair. Right? No, we don't need to hear anything. Is there a firing squad here? Can I do it? Because it's D.C. We saw what they did with Michael Sussman. The defendant has been given every indication, he intends to create a circus atmosphere, and the judge should stop that from happening. Says the defendant should also be precluded from making improper arguments that politicize the case. At every turn, the defendant has attempted to make this case about the politics, not about the law and the facts. It's like, hello, this whole thing is about that. Okay. There he claimed without support that available information suggests that political considerations played an impermissible role in the prosecution of Mr. Bannon. They say in his opposition to motion, okay, so they're going through motions now, and they're citing some other law. You can see this comes out of the D.C. Circuit from 1983. They say the political affiliations of members of Congress and their staff are irrelevant to the issues that are going to be raised at trial. Claims about members' politics were not relevant to any legal issue before the court, and so don't let Bannon come in here and start running his mouth. The government also anticipates the committee staff with any relevant testimony may be called as witnesses, and if they are called by the government, the defendant is going to cross-examine them. But the court retains discretion to rein in Bannon's cross-examinations and to stop him from beating him up. To the extent the defendant seeks to cross-examine committee staff about their personal political affiliations and about the political dynamics of the committee to suggest that he was subpoenaed or referred for contempt by political motivations is not appropriate. And they're saying the court should not allow him to do that. Writes, none of these issues are relevant to the defendant, whether he received a subpoena, whether he defied it, and so he shouldn't be able to ask them questions about any of that. And separate and apart from their irrelevance, they say there's no indication of any bias, even if they are Democrats. Bias is a relevant basis for cross-examination only when it goes to the witness's credibility, but that credibility has to be tied to something else. You see a lot of case law being referenced here. Finally, it would be otherwise improper for the defendant to call members or staff for the sole purpose of questioning them about their biases against the defendant. They say this type of impeachment evidence can only be used for certain things. They say claims about government misconduct are not proper issues for the jury to decide. So they're saying that Bannon is going to come in here and just smear the government all over this. No. They're saying you can't say that we're, biased anti-Trumpers. There's no evidence of that. Maybe it's true, but he's got no evidence of that is what they're saying. And so he can't flip the script, right? And the judge has to keep this thing narrowly focused, right? It's about this trial. They're not supposed to allow all this other stuff coming in. And so we'll see what the judge does. He says the defendant writes, Amanda Vaughn, the defendant, without identifying any legal basis for his claims, has repeatedly asserted the government engaged in misconduct in this case by treating his attorney, who spoke on his behalf to the committee, as a witness. He has always been. Bannon also has asserted that he intends to make baseless claims about government misconduct. We get some more rules about how that works. Prosecutor says, don't let him do that. And if Bannon, asks this prosecutor, if Bannon subpoenas members and staff of Congress, and should those subpoenas be quashed, he cannot argue at trial that because he didn't have his witnesses, that he should be acquitted. Right? They're saying if judge, if you don't allow him to subpoena these people to come in, he's going to complain at trial that I didn't get to present my witnesses. The government understands, and you can't let him do that. The government understands the defendant has issued trial subpoenas to various members and House representatives, and that the House members have moved to quash them. They say the House is not a party to this case. It's a separate branch of government, and it's not even part of the prosecution team. Nevertheless, although it is not clear how the dispute between the defendant and the House will be resolved, to the extent that any of the subpoenas are quashed, the defendant has indicated in his ceaseless effort to make this case about anything other than the facts of the law that he should be allowed to use his failure to secure the witness's appearance against the government. Right? The prosecutor is saying, look, judge, we can't make these Congress people show up here and give you testimony. And so if Bannon goes out there and tries to get them and they can't get in here because, Nancy Pelosi doesn't want to wake up and drag her butt down there, then this is going to be something that Bannon uses as a scapegoat. He's going to say, well, see, look, ladies and gentlemen, I mean, we couldn't even present our evidence, couldn't present our witnesses. I mean, we wanted Sergeant at Arms and Nancy Pelosi and Adam Schiff and Shifty Shift and Pencil Neck and Slippery Jamie. You know, I can't even present my evidence. So you have to find me not guilty. And the prosecutor was saying, no, he shouldn't be allowed to do that. They give us some rules on that. The defendant should be precluded from making irrelevant arguments about unavailable witnesses and quashed subpoenas. Saying evidence or argument about the misdemeanor nature of the charges is improper, right? He should not be allowed to comment on the penalties of the case, and that's pretty common stuff. Defendant should be precluded from making claims about other individuals who have not been prosecuted for contempt of Congress, right? Making the claims like, I'm being treated differently than this person. I've been prosecuted, this person has not. Saying counsel should be prohibited from making assertions to the jury based on claimed experience. So saying something like, at various times in the prosecution, counsel to the defendant have cited previous experience as evidence of their arguments. Saying, you know, I've been a prosecutor myself for a long period of time. And so saying he shouldn't be allowed to do that, right? I've been, you know, one of those, I've been around for 35 years. Therefore, you know, I've seen a case like this. And, you know, this is pretty interesting because prosecutors kind of do that. And they don't get scolded too badly for that. Like, for example, the one I'm thinking about, we talked about here, was in the Michael Sussman case. We had prosecutor DeFilippis, Andrew DeFilippis, was having a conversation, I think during closing arguments. And he went out and he said, ladies and gentlemen, look, I've seen close cases. This is not even a close case. Not even close. Remember something like that? That's kind of an experiential argument. I've been around the block. This one's like really serious. And they're trying to stop that from happening. The defendant, and their prosecutors and Durham's prosecutors made an argument like that, right? The defendant should be precluded from presenting evidence or argument about the jury relating to the merits of purely legal issues, saying as he left the courthouse on June 15th, just a couple days ago, after the hearing on the motion to dismiss, the defendant was asked by the press why he continued to assert the committee was illegitimate when the court rejected his claims at the hearing. The defendant responded saying that he would continue to argue their legitimacy in court. While leaving court, Bannon threatens a real investigation of J6 after the midterms, which is true. I hope that happens. The defendant's claims about the committee's constitutional and statutory validity, however, do not raise factual questions for the jury, nor do his claims that executive privilege did, in fact, excuse his compliance with the committee subpoena. His legal claims on these issues did not have merit when he raised them, and so don't let him do it in front of the jury. They say the rules give you the ability to do that. They also say the committee's constitutional and statutory legitimacy are not factual questions for the jurors. So don't let him make arguments about it. Don't let him go in there and say what I've been screaming about for the last several months. Illegal. 13 members. They've only got 9. Supposed to have 13, 5 to 8. It's not that. It's 7 to 2. Congress is a representative body. It's supposed to be representative. It's not in this select committee. It'd be like going to pick any state and saying, well, we're only going to give you like a third of your representatives. You cool with that? It's representative enough. And you say, but those aren't even my representatives. Like, they're not even real Republicans, Kinzinger and Cheney. And they say, well, they're close enough. We're going to take half your representatives, and we're going to also give you representatives that are like the worst in the world to actually represent you. Basically representing the other team. You cool with that? Everybody here in the DOJ and in apparently the DC circuit, it's like, yeah, no, that sounds good. It's close enough. Whatever. And these are like conservative judges. And I haven't seen a good explanation as to why, other than apparently in the oral arguments that took place on the 15th, the idea was Congress implicitly ratified them. The committee or something. I don't know. I still don't get it. But apparently that's what happened. You can see we're getting to the conclusion of this, and the prosecutors are just trying to stop him from making certain arguments. Whether executive privilege excused the defendants from being required to show up for the committee, they're saying that's not a factual question for the jury. So don't let him make arguments about that. Saying he cannot argue to the jury that executive privilege excused him from complying with the law. They say the defendant never clearly raised executive privilege as a basis for dismissing the charges. Instead, he raised it primarily saying he had good faith reliance on the defense, sort of like it was affirmative, kind of a defense type of thing. As the government has acknowledged several times, Supreme Court law says whatever. Moreover, there are no questions of fact that are bound up, right? More legal analysis taking place here. They talk about count 1, more legal analysis. We've got all the DC Circuit opinions being dropped in here. Keeps on going, 1997. They say no matter what the facts might show, therefore, about the extent and breadth of the president's invocation of the executive privilege as a matter of law, it's a complicated legal issue. And that's, that's a whole nother reason why this is so problematic. This executive branch versus fake select committee thing. It's ridiculous. He says, the prosecutor says, as a matter of law, executive privilege provided no basis for what is alleged in the indictment. Total noncompliance, right? They're saying that Bannon should have responded and invoked certain things, and they're saying he didn't do anything. So if the January 6th committee invites him to the birthday, he should have RSVP'd no rather than just not RSVPing, is what they're saying. Like his claims relating to the committees and the subpoena's legislative purpose and the committee's procedural rules, he must be barred from making those arguments and presenting testimony or evidence related to the merits. This case is about whether he was subpoenaed and whether he showed up, not about anything else. And so remember, on this channel, we illustrate this constant ebb and flow, this back and forth, constantly talking about the hula hoop and the scope of the arguments that are being made. Remember that cases are won and lost on these issues. Sometimes prosecutors, they really want to talk about a lot of other things. Like in the Kyle Rittenhouse case, for example, right? It wasn't just about that one incident. It was about what he did the night before and other violations and everything he did after that. I mean, they really went like 2 weeks before and like weeks after. And he showed up in this and he wore a shirt that said this and all of those things, right? Really expanding the scope. Whereas in other cases, it's like, no, you keep it extremely narrow. Like right here, the prosecutors, very narrow. It's only about showing up at the hearing, and we don't want the jury to be confused. The size of the hula hoop, what's inside, what's outside, all very important to the conclusion of these cases. And we've got Steve Bannon coming up for a jury trial very soon in July. We're going to be covering it in depth. Remember that this is all available, or following along on this is all available at j6mindmap.com. If you're kind of following the entire saga, Steve Bannon is only one small piece of this. Former Trump advisor, indicted for a process crime emanating from the January 6th investigation. And so I think this one's going to go the entirety of the game. It's going to be all the way a full trial. Might even see a conviction out of the DC Circuit Court. And what that does in terms of galvanizing the Donald Trump base, Steve Bannon has a huge audience of people who are going to be very upset about that. Could get interesting. We'll continue to follow along. I hope you join us in that journey. I appreciate you supporting the work and the coverage that we do here. Whether you join as a member, I'm creating now member-only videos that are going out and trying to get on a once-a-day frequency cadence. So if you're looking for a little bit more or a little behind-the-scenes stuff in the morning for me walking around, whether you join on locals or on members on YouTube, I greatly appreciate it. Many of my videos get demonetized instantly. We don't show up in the search results. And it's a difficult game to be playing here on YouTube. So I appreciate the support. Always appreciate a like, a thumbs up before you get out of here. If you know anybody in the state of Arizona or was traveling to the state of Arizona charged with a crime, links to my law firm are also down in the description below. We have a mission to help good people charged with crimes find safety, clarity, and hope. We'd love the opportunity to help. So that is it for me, my friends. Until the next Steve Bannon update, I look forward to seeing you on the next one.